Hello, I'm Eric Kennedy, the Director of Advocacy for the Kentucky School Boards Association. And with
I'm
me,
Katrina Kinman. I'm Director of Policy and E-Meeting Services at the Kentucky School Boards Association.
thanks Katrina, and we are wanted to come to you today and provide this training resource electronically, which will also be able to be counted as a self-study for any school board member who watches this resource and then submits the self-study credit form to KSBA board team development staff after it's over. Over the last several weeks, today is about April 15th. Over the last week and a half, of course, all of our members, school board members, have had a lot of questions and a lot of things changing out there, largely because of the COVID-19 pandemic. There are a lot of things swirling. A lot of guidance has been coming out from us, from the Department of Education, and other government agencies. And we've had a lot of questions that have come in from our members. And, you know, it's hard to keep track of all of it. And so we wanted to come today and try to focus amongst all of the noise and all of the issues that are swirling and really zero in and focus on some of the issues that are directly related to what a board member and a board team has to deal with. These are some of the issues that directly impact what is under a school board's authority, maybe that as opposed to something at the school level, something that a site-based council or a principal or even individual classroom teachers might be dealing with. School boards, by and large, you're not involved with the day-to-day work of non-traditional instruction and what that looks like and so forth. But there are some things that are directly in the authority and only in the sole authority of the school boards in each local district to consider and take action on relating to the COVID-19 pandemic. So as a service, we wanted to really identify what some of those issues are and zero in today, providing some targeted information and guidance about the state law and regulation and your local board policy and help you sort of consider actions that you may decide to take. Several school boards across the state have already, even in the last couple of days, even yesterday, have had meetings and taken action on some of these issues that we will go through. And so it is very timely to not only look at the example of some school boards that have taken these actions, but also look at what some of the other districts across the state are looking to do in the very near future. And so to begin, we are looking at the top 5 COVID-19 pandemic issues facing school boards. But of course, at KSBA, we always want to begin first and foremost by explaining that in all of our guidance, in all of our training documents, and all of the information, and even the policy language that we help craft and help work with school boards on, we want to always encourage you to reach out first as a school board to your superintendent, to your board attorney, your board counsel, and ask their advice and guidance on all of these issues. So as we begin, we want to say when in first on all of the things we'll talk about today and these issues and any other COVID-19 related issue. When in doubt, first consult your superintendent and your board attorney. Then consult your district policy manual. And finally, rely on some of the guidance documents such as this resource and all of the resources that are available on our website. And then, of course, when in doubt, reach out to us and contact us by call or email, even as we are all working remotely, like all of the staff, most of the staff in districts. We are still available to help answer questions and provide information. And I think I want to stop now and let Katrina make a comment about your policy manual at this point.
That's right, Eric. Thank you. While everyone is working remotely right now, you don't have access to your hard copy of your policy manual, or in general, you probably don't unless you maintain a copy at home. With that being said, most school districts have posted a link to the district website to their online policy manual, and that is maintained by KSBA. It should reflect your actual policies and procedures that we have processed for you. Bearing in mind, if you haven't sent it to us yet, it won't be updated there yet. But in general, your policies and procedures can be found on the online manual on the district website, but you can go to KSBA's website and under the services tab and policy, then find online manual, and you can access many districts' online manuals there if they've chosen to put that link on our website. It's fully searchable, so if you're looking for the word emergency, that will come up, and any related policies or procedures that have that particular word in it will be reflected in the search feature.
Thank you, Katrina. And I myself use that website. Our own policy, which most districts have their policies there. I use it all the time. And in the last couple of weeks, as questions, for example, about emergency leave have come up, even I myself have used that as an easy way to compare local school boards across the state to see who has a given version of an emergency leave policy and who doesn't. So even you may find that helpful if you're trying to consider various policies on what you as a school board want to do, to think of, well, what is the district next door, or what is, a district close by, and what kind of policy do they have?
Thank you, Eric. I do want to point a cautionary note there, though. If you're considering using similar language from another district, please consult your assigned policy consultant at KSBA first. We have behind the scenes information on all the different particular policies and procedures, because ultimately that language belongs to the Board of Education. But for whatever reason, maybe many years ago, the board made a decision, and we may have flagged that as do not recommend for a particular reason, and it wouldn't be reflected in that district's online manual.
Yeah.
Always reach out to us first before making any policy changes, so and look for those type of pitfalls for you.
Absolutely. So what are the top 5 COVID-19 related board issues that are directly related to something that the school board needs to be considering or possibly taking action on? We feel that they are reflected here. Amending your district calendar for this year and adopting one for next year. Granting emergency leave, that is paid leave, to your employees under the state Senate Bill 177 provisions. Possibly waiving graduation requirements. As you know, the state, by administrative regulation at the state Board of Education level, there are some minimum state graduation requirements that are applying across all districts. But by law, each local school board, as you know, may adopt additional requirements only in your district. To the extent you may have done so, we are going to discuss that you might want to consider waiving some of those requirements only for the seniors graduating high school this year. The fourth, amending your certified evaluation plans, or your CEPs. That is the district plan for how your administrators evaluate all of your certified employees, your teachers, administrators, and others. You may possibly, because of the situation and everyone working remotely, you may want to consider making some adjustments to that plan only for this year. And finally, the public comment period during your local school board meetings. Whether or not you allow public comments during meetings that you are most likely holding remotely right now, and what that might look like, and any changes you might want to make. So beginning with the first issue, amending the school calendar. As you know, here we have reflected that is 702 KAR 7:140. As you know, that is a state administrative regulation. That is what administrative regulations look like. Anytime you see that, that is something that our state Board of Education has adopted. It has the force of law. As you can see there, we've noted that in that regulation, it requires districts to adopt a school calendar for the upcoming school year on or before May 15th of each year. And there are certain procedural steps in that process by statute that you have to follow in order to do that. And so that May 15th deadline is facing you coming up pretty soon for next year's school calendar. And before that happens, you have to have a sort of advisory committee formed locally of various stakeholders to give the board several options to consider when you, the local school board of education, adopts that calendar. Because boards are meeting largely remotely, because those advisory committees probably would have to meet remotely at this time, and because we don't know, there's a lot still left that we don't know about when this school year may or may not end in each district. We don't know when we will be able to return to work as normal in person. Because of this uncertainty, it is very unlikely that districts would meet that May 15th deadline with any real certainty to what next year's calendar should look like. We frankly don't even know at this point when we may or may not be able to begin in-person school for next year, or what that looks like. So very recently, I believe maybe a week or a week and a half ago, the State Board of Education met, and they have waived some of these requirements that you see in this regulation. And I see there's a policy reference there at the bottom of the page. I'll let Katrina speak briefly to that policy and what that refers to.
Thank you, Eric. Policy reference 08.3 is the school calendar policy, and it has the steps that are required in place for that district calendar committee that Eric was speaking to, because the regulations have been waived, but KRS 158.170 still requires that district calendar committee and their input of those various stakeholders. That committee is subject to the Open Meetings Act, just like the board and any other committee of the board. So they would have to have notice of their virtual meetings, just like the school board meetings. Also, a related policy to that is 01.42, which is the regular meeting board policy, because it has the requirements in it for the special notice of the meeting of any time that board is talking about adopting that calendar going forward. So those two policies together, 08.3 and related policy 01.42, will give you guidance as to the steps that need to be taken for that district calendar committee.
Perfect. So that is something to keep in mind for the two reasons. As we can see here, because you're maybe unable to plan for your school calendar for next year as required, as we said, the Board of Education has waived the deadlines set forth in Section 1, 2, and 3 of that regulation for the remainder of this fiscal year. And so not only could your school board may consider making changes to this current school year's calendar, many districts, for example, had planned to have a certain spring break, and then the school board decided to go ahead and work through and have NTI instruction during the spring break for certain reasons. So you may, as a school board, be considering making changes to this school year calendar, and then also looking forward, doing all of those procedural steps that Katrina explained that are in those policies there she referenced, in terms of setting up that advisory committee, having it meet, taking all of those procedural steps. All of those steps and that process is still required, but the deadlines in reg have been waived and extended for you to have a little bit more time to do all of those things and to make some of those decisions for next year's calendar. So definitely something only the local Board of Education has the power to adopt the district's school calendar. So this is a perfect example of something that, of all the other issues swirling about the situation, something that the boards should really focus on is this piece. Moving ahead. The next issue that we have had a lot of discussion about deals with your employees and emergency leave. Now, we are going to talk today in this training resource only about state law that has changed. When we say Senate Bill 177, that is a state law that has already passed by our state General Assembly in Frankfort and has already taken effect. You probably have gotten a lot of information from us and others about some federal laws dealing with other forms of federal emergency leave and sick leave that are now also in effect from Congress at the national level. We are not going to deal with that today. We are going to really zero in and focus on, yet again, that federal law. To a great extent, that just is in place and applies, and there's no decision that needs to be made by the school board. This state law and this form of emergency leave is something that is entirely up to the discretion and power of you, the local school board. So as we see, Senate Bill 177 took effect back on March 24th. This bill gives a lot of flexibility to local school boards to allow emergency leave beyond what is normally allowed under state statute. So already for many years under Kentucky state law, every school board has had the power to grant up to 3 days of paid emergency leave only to full-time employees. As you can see there, KRS 161.152 gives school boards that option to allow, you don't have to allow any, but by policy, a school board may decide to allow up to 3 days of paid emergency leave to only full-time employees. And the reasons that you might award that leave were also largely up to the discretion of each local board. You are not required to provide emergency leave at all if you don't want to. And when you start looking at board policies, some boards allow only 1 day Some say up to 3. Some boards have adopted policies locally that set out certain reasons that emergency leave may be granted. Some have sort of a catch-all provision that says any other leave or any other reason of some emergency situation at the discretion of the superintendent. So all of the boards, because this has a lot of flexibility built into it, a lot of policies are already varied across the state. We might want to back up one slide to show those policy reference numbers that Katrina might want to make note of. If we back up
That's
one,
okay.
right
Thank
there.
you, Eric. It's 03.1236 and 03.2236. Now, I will point out, as Eric said, this is totally optional for a local board of education. So if you don't currently have emergency leave policies, we don't feel like under this temporary situation that you need to enact such at the moment. And I think we're going to get into that in a little bit more detail in the slides that are upcoming. But these are the policy references: 03.1236 for certified and 03.2236 for classified employees.
Thank you. So then we'll go ahead and advance, I think, a couple of slides. So how does that legislation address emergency leave? This slide and the next one are the exact wording from Senate Bill 177. It says there again, that statute that you see there says you can allow up to 3 days of leave only for full-time employees. So what about part-time employees? And what if you need a lot more than 3 days this year because of the pandemic? The General Assembly, if you back up one more, the General Assembly said notwithstanding that statute. So even though it says up to 3 days and only for full-time folks, now only during this one school year, the 1920 school year, a local board of education shall allow emergency leave to any full-time or part-time, classified or certified employee if, on the next slide, if the local board determines it is necessary in relation to the COVID-19 public health emergency. A local board shall waive any requirement for the employee to file a personal affidavit in order to take this leave if it's allowed. So the most important word there in that legislation is if. This gives entire flexibility and authority to no one else in the district other than the local school board to determine, in possibly at an individual employee basis, maybe employee by employee, if there's a need for more than 3 days of emergency leave, or if a part-time person needs this leave, or maybe a district-wide decision. If you are in a location that has had a substantial outbreak of the COVID-19 virus and it is causing major problems for you, you may come together as a board and say, we have determined it's necessary for all of our employees to have X number of days of emergency leave in order to be paid and to not work. Any of those various decisions with all of this flexibility has really been granted to the school board to go over and above the normal limits in the statute. Next slide. So does that mean that the school board must provide emergency leave to anyone at all if it doesn't now, or any more than you normally do? No. This law does not require emergency leave to be granted if the local school board does not determine that it is necessary. Next slide. As you can see, the boards have discretion to determine whether or not any emergency leave is required for any employees based on, as I said, the district-wide considerations and also maybe considerations regarding individual employee situations. It's actually, we feel that it is pretty unique and rare for something to have this much leeway and flexibility in it in terms of Kentucky state law governing school boards, frankly. Does Senate Bill 177 mean that school boards must provide emergency leave? As you can see, a school board could determine that some form of emergency leave is necessary for some employees and could allow that leave, even if you don't normally have leave by policy. And this, I think, is something Katrina referred to earlier. Many school boards have the policies already in place for some emergency leave and some do not because it's currently optional. If you are a school board that does not have this policy in place and you have never allowed emergency leave to anyone before, Senate Bill 177 empowers you to potentially allow for emergency leave to be granted only during this school year, only in relation to this COVID-19 pandemic, even if you don't normally do so. And I think, Katrina, if you wanted to stop here and comment again on how we think a board might do that without adopting a policy right now.
That's right. We believe that you can have a resolution, you can pass what a protocol, anything that doesn't need to be permanently codified in your policy manual at the time, because this truly is temporary and it's only during this actual emergency. So our impression is that you don't need to make a permanent change to policy right now based on this emergency leave. And if we get back, I think it's in one of the slides coming up, we'll talk about the extraordinary circumstances language, and I'll speak a little bit more to that when we get to that slide.
Sure. So the next slide. Must school boards provide an unlimited number of emergency leave days? No. As we've said, the Senate Bill 177 provides discretion for school boards to act on this issue. It does not appear that the bill is intended to require a school board to allow unlimited number of emergency leave days to any employees, unless the board determines that that is necessary. With all of the flexibility there, we think a board could put a certain number of days in place for all employees. It could handle it just on a purely individual employee basis and just sort of say employees have to come and request emergency leave, and then the superintendent might be empowered to grant sort of only as necessary. So no, it does not say that every employee now has unlimited emergency leave days. There you guys, and we've spoken to this previously a little. What aspects of the existing emergency leave statute do not apply now? Senate Bill 177 effectively removed the normal limit of 3 days for emergency leave, and it also broadens it to possibly be granted to any full-time or part-time employees of the district. As I said earlier, the statute up until now and beginning next year, this is only for this school year. So for next school year, it reverts back to the statute, which says no more than 3 days only for part-time folks. And it also does say, Senate Bill 177 does say that if the local school board determines it is necessary to grant any form of additional emergency leave to any employees, if you make that determination, that even now by your local policy, if you say that you require a personal affidavit to be signed and notarized by an employee asking for this leave, it does, in this way, it's not flexible. It does say if you determine that emergency leave is to be granted for this situation, you cannot require an employee to submit an affidavit in order to take that. The thought process behind that was that when the board gets together and determines that it's necessary, you are in a sense finding that because of this emergency that we are all under, emergency leave is necessary for someone to not even come to work. Therefore, it would be so impossible probably for that same employee to come get an affidavit signed and written, notarized in all likelihood and turned in. So the General Assembly went ahead and said, you cannot require that in this circumstance. Here we go. Do school boards have to create and adopt any new policy under Senate Bill 177? No. This addresses an emergency situation. It is only effective temporarily just for this one school year that we are in. Many school boards already have emergency leave policies that sort of at the end say something to the effect of such other reasons of an emergency or extraordinary nature as approved by the superintendent. So we think that because this is the state law is temporary and will go away, that we think that a school board could just adopt a motion in a meeting to allow this leave with any certain parameters to it, or even just sort of take advantage of this type of language that's in place to sort of empower the superintendent to award additional leave under certain parameters without adopting an all-new policy or making a permanent change to their policy, which takes a lot of time and might make your board meeting that is already somewhat unusual because it's virtual longer than it otherwise necessarily needs to be. I think I'll let Katrina speak to this as well.
That's a really good point, Eric. As I said, most districts that have emergency leave policies already have the language regarding the emergency or extraordinary circumstances. But a couple of districts have reached out to us because they didn't have that language, which gave the superintendent wherewithal. So in many instances during an emergency, such as we're in right now, if the board does need to amend this policy, maybe to include that emergency or extraordinary language, the board policy 01.5, which is your school board policy, allows for one emergency reading of policy if declared in. So if it truly is an emergency and you need to amend a policy for reason, although we don't think you need to do so, as we've already said, for these particular ones, you can do that in one reading as long as that is reflected in the minutes as to why it was a one-time emergency reading of policy rather than waiting and having two readings. So I just wanted to put that is an option. It's not done often, but it's an opportunity if your board needs to do that. And if so, contact your policy consultant at KSBA.
Thank you so much. And there again, we want to keep reiterating that when you're doing anything with your policies, please reach out to your KSBA policy consultant, not only to help give advice or help you come up with wording, but also to ensure that you do it and adopt anything you do correctly, and that we also know about it at KSBA to make sure it's reflected in our database of your policies as well. So moving on, what about employees who provide essential services? A board could grant authority to the superintendent to consider whether individual employees or maybe a class of employees, such as all food service or all janitorial staff, to determine whether or not they are essential to operations. The board cannot alter an individual employee's eligibility to take any paid or unpaid leave under the federal laws that have recently been passed that we mentioned earlier. So federal law, nothing you do can change that. That is already in place, and it grants certain rights to certain leave to employees. But you could, in terms of what we're looking at here, take into account whether an employee or a class of employees is essential when you're thinking of granting out emergency leave. Okay, as we said earlier, what about school boards that do not have any emergency leave policy in place right now? You've never allowed it. As we said earlier, those school boards could take action to authorize the use of emergency leave now in this school year for this circumstance under Senate Bill 177. This could be done by just a temporary resolution that the board adopts or a certain protocol, or just simply making a motion to this effect and putting all of the parameters in place without codifying any permanent policy language, which you wouldn't need probably ever on your books again after this year. Just so long as you make sure that everything you adopt and do is recorded in the official minutes of your meeting, which is of course kept permanently as part of the permanent official legal records of board action in your district, which is extremely important to keep in mind. Now, a lot of districts have, for this issue and also for how they hold their meetings virtually, they've adopted language and then called us and said, well, do I need to send this to you, or do I need to file this with someone at Frankfurt? Generally, no. Generally, so long as things are reflected very detailed in the minutes of the board meeting, that is the most important place where all of the official records are housed. Can school boards require employees to use sick leave where there is an emergency need for leave that does not otherwise qualify? As you can see, there are some policy references there. I believe those, Katrina, are those the sick leave policies?
Those are 03.1232 is for certified, 03.2232 is for classified. And yes, those are leave policies, which are related policies to emergency leave.
That's right. So when you look up those policies and also that state statute noted there, that is the sick leave statute, the state law, you will notice that it says in general, no. The existing emergency leave statute provides that emergency leave already for all these years may be provided by a board, and it will not affect the employee's sick leave and shall not be treated as having an effect on the provisions of KRS 161.155. In other words, keep in mind that emergency leave is a totally separate type of paid leave similar to sick leave. And so if an employee is granted an emergency day of leave and uses it, that is to have no impact on any sick days that they may also have. You can't really require a sick day to be used up before you have emergency leave. And in terms of service credit for the retirement systems, we have now gotten confirmation from both the teachers' retirement system and the county employees' retirement system, TRS and CERS. Both of those agencies have said that emergency leave granted under these state laws and policies, emergency leave granted is paid leave, and that is treated as the same as any other kind of leave. It's treated the same as if you worked that day in terms of earning service credit towards retirement. You can see here, the sick leave statute does authorize the use of up to 3 sick leave days for an emergency purpose, if permitted in board policy. So you can see there, if a board policy currently allows that an employee can use up to 3 sick days for an emergency reason, that would still be in place and would still be the law. As is already the case for many boards that have existing emergency leave policies, we mentioned this earlier, boards could consider just permitting the use of emergency leave under Senate Bill 177 under that catch-all provision we mentioned. It says such other reasons of an emergency or extraordinary nature as approved by the superintendent. Just yesterday, I know Katrina and I were just discussing that one district reached out to KSBA staff yesterday and sort of said, well, what exactly would the board need to do? What would the motion need to say? And we said, well, look at your board policy. If you have this language as part of your board policy for emergency leave already, there might not be that much the board has to do. The school board could simply make a motion to really explicitly say, now for this school year under Senate Bill 177, we specifically empower the superintendent to grant perhaps more than 3 days of emergency leave if it's related to the COVID-19 pandemic under this provision, simply being sort of another reason of an emergency nature as approved by the superintendent. There again, that sort of, it's all flexible, taking that sort of action so long as that is carefully reflected in the minutes of the meeting and put on record and kept there, we think might be sufficient if you have this kind of language you want to rely on in your policy. Okay, switching gears completely to the second, I think, of our sort of top 5 COVID issues that you may face, to graduation requirements. Moving a little bit more quickly, the state requires, as we said at the beginning, by state administrative regulation, every high school student has to earn a minimum of 22 credit hours for graduation, no matter what district you are in Kentucky. However, by law, local school boards can adopt additional requirements for graduation over and above the 22 credit hours, or even other types of requirements. We know that at least 29 local boards, by local board policy, require more credit hours than the state minimum number of 22. Some other local boards, and it may or may not be explicitly written in your policy, but we know some other local boards also require students to demonstrate transition readiness in various ways, such as either completing some capstone project, or some districts have sort of senior interviews where every high school senior has to be interviewed and present something to a panel of community leaders in order to demonstrate readiness and to graduate. And that is a graduation requirement only in that school district. Before we go into some actions that the State Board of Ed has taken, I want Katrina to speak a little bit about how complex this policy number that's referenced here can be in some cases.
Thank you, Eric. Actually, your graduation requirements policy is 08.113. Last year we updated it in the update for the changes that were made to the regulation that go beyond, many boards had put more information in beyond those 22 credit hours, excuse me. One thing I do want to point out is the board has the authority to waive their policies or portions of policies under just existing statutes that they've always been able to do. KRS 160.160 and KRS 160.290 both address the powers of the Board of Education. So if the board sets the policy, they can certainly waive their own policies. they can make a request to waive regulation, but not statute. So if your board currently requires some of these transition readiness pieces, or more hours above that, then that's a possibility for your local board to make those decisions to waive some of that right now. And once
Perfect.
again,
So,
I'm sorry, Eric.
Go ahead.
Once again, you don't necessarily want to make a permanent change to board policy, because this is for your current senior class for the existing school year, and probably wouldn't want to do that going forward.
Thank you. Absolutely. That was the point I was going to make. There again, like so much of this, all of the things that are related to the COVID-19 pandemic, you probably don't want to go into your district's graduation requirement policy and make a permanent change. You probably don't want to get rid of, if you have additional requirements, you may not want to get rid of them forever. But maybe there might be a reason, if you determine as a board that either if it's additional credit hours, if the seniors of your high school class this year would have a difficult time finishing those credit hours, whatever given class it is, because we have switched to NTI, whatever your local circumstances, if it would be sort of a hardship for your seniors to meet your local additional requirements this year, especially if it's something like an interview to a committee of people where basically people are not able to meet in person right now for such an interview to take place, and if that would be an extra burden and hardship for your staff and your students and families, that may be something that you as a local board want to waive, but that would only be for this one graduating class of seniors. So as Katrina said, under existing state law from forever, if it's something that's only in your board policy, you as a board could make a motion and approve an action in a meeting to waive a policy or just part of a policy that you have. And to help you consider all of the things on this issue that you would need to consider, the Department of Education in Frankfort, KDE, if we want to come back one slide, KDE has issued guidance explaining that you can waive any of these extra requirements if you determine it's necessary. That document of guidance, not only has it been sent to you by KDE already, it is, I believe, on KSBA's website that we will mention at the end of this presentation for you to find there. We have also forwarded that out to you. It really helps you take into account step by step all of the aspects of this issue that you may not otherwise think of. You may sit down and think, well, there's no reason we wouldn't need to waive anything. But then when you really step through and this guidance document helps you consider all of the things that we're facing because of the virus and the pandemic, you may then think, actually, there is a reason why we want to waive this year. So please look to that guidance when you as a board get together and discuss this. Next slide. There again, as Katrina also mentioned this briefly as well, KDE officials have also noted that another option that they may take at the state level would be for the Department of Ed or for a local Board of Education to ask the KBE, the State Board of Education, to waive the state required 7 electives. So when we said earlier that the state minimum is 22 credit hours to graduate, 7 of those credit hours are electives. They are elective courses that right now students have to take. It is possible, we don't know if it's likely at this point, but it is at least possible that the State Board of Education could come together in a meeting and waive those 7 elective requirements, which would then sort of automatically say that a high school senior this year would only need the 15 required credit hours in order to graduate. That has not happened yet. That may or may not happen between now and the end of this school year, but that is something to be aware of. And also knowing that you have the power, as Katrina mentioned, a local board can ask the State Board of Education for a waiver of any administrative regulation that is in place. So since this isn't new, by them saying that a local board could ask the state board to waive those electives, essentially you can already ask them to waive anything that's in regulation. You have to demonstrate a need for it, and they may or may not grant that. So that's another aspect to keep in mind. And now graduation ceremonies. Everyone in the entire public education community in Kentucky wants this year's seniors to be honored and celebrated as much as possible, given the circumstance that they've been put under. But remember that graduation ceremonies are just that. They are just ceremonies. The graduation ceremony itself doesn't have legal restrictions on it in state statute or regulation. They can occur before or after the last instructional day of the year. So you could have a ceremony and kids could walk across the stage and get just a piece of paper that's not the diploma. And that could even happen before the last instructional day. Really, the point here is this is entirely up to local decision making and local control. Districts already currently can have any kind of graduation ceremony almost that they want. And now, given the pandemic and all of the restrictions on all of us meeting in person and having large gatherings of people, school boards and high school administrators and seniors, high school seniors and their families are discussing what can we do to have a graduation this year. Some districts are already moving forward with virtual graduation ceremonies. At least one district I'm aware of is all of their caps and gowns arrived at the school. They are delivering those. School staff and school buses are delivering those door to door to their seniors, not making any physical contact with them. The seniors are sort of putting on the regalia and taking some pictures, and they're going to have a virtual graduation ceremony later to honor them. Others are just looking to delay the graduation ceremony until later this summer or even next year. Really, there is the point we want to leave you with is that all of this is really up to flexibility at the local level. There are not a lot of restrictions in policy, state regulation, or state law on what graduation ceremonies have to look like. So there won't be much need to ask for approval of any alternative form of graduation from the Department of Education in Frankfort or any other sort of entity. That is something that everyone at the local level should be giving consideration to. Now, I think moving to the next big topic that is directly something that each local school board has in its authority to act on, the Certified Evaluation Plans, or you may see it noted as CEP. As we said, there are a lot of, it's unlike graduation ceremonies, there are a lot of rules governing what the Certified Evaluation Plan has to look like in each district. There are restrictions in state statute for what that plan looks like and how the process by which each district's plan is created. And by regulation, there are a lot of restrictions on how you formulate that plan in your district. However, because a lot of that deals with in-person observations of the teachers and then meetings between an administrator and a teacher, especially in going over some of their work, that now it is hard to evaluate. In some cases, it's hard to observe what a teacher might be doing with NTI. It is also very difficult to meet in person to talk to even between an administrator and a teacher. Because of the pandemic, again, under Senate Bill 177, the state legislature has granted a lot of flexibility to the local school board to make changes to your district's evaluation plan only for this year. Great flexibility has been given to you. Just like with some of the other issues, we do not believe that you need to adopt any new or formal amendment to a policy to make a change to your CEP only for this year. KDE approval is not required. If you as a local school board want to adopt any changes to your CEP for this year, whether it's delaying parts of it into next year, delaying the in-person observations, or simply sort of foregoing some of the CEP activities for only this year for some employees versus others, KDE approval of that is not necessary. So you may alter deadlines, you may alter the format, you may have observations remotely instead of in person. There is great leeway for what you can do at the district level. And the Department of Education has yet again put a lot of guidance together to help you formulate what your plan might need to look like and to help you think through what changes are possible. All of that is available on the KDE's website, and they've been pushing out some of that information to superintendents recently as well. And so for you to get a sense of what yours looks like, Katrina can discuss the policy reference there on the screen.
Thank you, Eric. Policy reference 03.18 deals with certified evaluation. And I don't believe that there needs to be any type of amendments to policy, but only to the plan themselves. One thing, though, that I do want to point out, and you'll see I didn't reference it here because this is silent when it comes to classified evaluations, because they're not required by law. However, most districts do evaluate their classified employees annually, and that is policy 03.28. So that may be another instance where the local board may want to waive a portion of that policy or the policy completely, waive deadlines to actually evaluate those classified employees, because all of these Senate Bills 177 was silent when it comes to classified evaluations, since they are not required by law.
Thank you, Katrina. That's such a good point, because we have had questions about that from some superintendents as well. What about all of our classified folks? So it's always important to look at the exact language. When we say that it was flexible, we mean it. This is quoting, this is the language that is now from the Senate Bill 177 has the force of law. Notwithstanding, which sort of means no matter what this law says, this is in place. So notwithstanding KRS 156.557 and the regulation 704 KAR 3:370, for this year, for the 2019-2020 school year, a local board of education may revise the district's certified evaluation plan due to the COVID-19 public health emergency, period. It doesn't put any other parameters or restrictions on that, so there is pretty expansive authority for each district board to come up with what changes it feels are necessary. We know many districts and many school boards have already adopted changes to their CEP. Many are currently right in the middle of thinking what they might need to change. And yet again, this is something that only the local school board can take official action on. And I believe our final of the top 5 COVID-19 related issues that are uniquely in the board's authority to take action on, we wanted to talk a little bit about public comment at board meetings. We've had a lot of questions when I think virtually every school board at this point has now stopped holding in-person meetings of the school board, as every state board and commission and entity has done. Everyone's working remotely and meeting with video teleconferencing through various programs under the CDC guidance, under the guidance of Governor Andy Beshear and our public health officials in Frankfurt. We certainly just, as the governor has, we at KSBA just implore school boards to meet remotely and to have maximum social distancing to keep you and everyone else in your community safe and healthy. But when it comes to public comment, state law does not require school boards to allow public comments during board meetings, although most boards do include a public comment period during meetings through local board policy. So we also highly recommend that. I think KSBA really highly values at the local level public comment to the local elected school board members. We recommend that boards have such a policy for public participation in their board meetings, and many do. However, because this is not required in state statute or regulation, as we've said on some of these other issues, if something is only a requirement in your district under your board policy, then the school board can waive all of a policy or parts of a policy, certainly for a temporary circumstance or a temporary period of time. And so this policy, like any other, your local policy requiring or allowing public comment in meetings may be waived by the school board during the COVID-19 emergency, during a time where you are meeting remotely. We've had a lot of questions about this, although, as I said, we recommend that boards allow public comment. Given the difficulty or the complete impossibility of having true public comments during a board meeting that is being live streamed over the internet with a video teleconference software, we really think it is just impractical to allow public comment in that forum. And so we are recommending that local boards in a meeting make a motion and approve a temporary waiver of your public comment period only during video teleconference meetings that you're having during this public health emergency. If a board were to choose to do that and waive that, you could consider many other ways for public feedback to come to you as board members in the district. You certainly could communicate your contact information at the central office and encourage folks, parents, and community members to reach out to, whether it's the superintendent or board members individually. All of that could still be something that you do. I know some districts are publicizing that folks can send questions to the superintendent and that he or she might publicly provide sort of a question and answer document in a similar way that the department at Frankfurt KDE is doing currently. There are lots of ways there, again, with lots of local flexibility for boards to determine how to proceed on this. Katrina, if you want to discuss that actual policy reference.
Yes, that is public participation in meetings, which is 01.421. Also, your regular meeting policy is 01.42, which could also have reference to public comment portion if you've added language there. One thing I do want to point out, I believe under the guidance that the Attorney General put out and we have put out, that this, because a meeting is just a video teleconference meeting under the current circumstances, that doesn't make that a special called meeting. However, one thing we do want to caution you about is when you do start your public comments back up, you choose to waive them during these emergency times. We really don't recommend that you allow for public comments at a special called meeting because you're limited to the topics that are listed on that special call meeting notice and agenda. And in that public comment portion, a person from the community may want to talk about something that's not on that agenda. We don't want you to run afoul of the open meeting. So that's just one other thing to point out. But certainly waive the portions of those policies that do require a public comment period through your local board.
Thank you, Katrina. And you raised an interesting point too about regular meetings do not become special meetings just because they are being video conferenced and streamed. A similar issues come up with, in a special meeting, you can only discuss things on the agenda. Even in regular meetings now, if you were to live stream your meeting over just using YouTube, if it was to be live streamed over YouTube or Facebook Live, which a lot of boards are using as a convenient way to provide for that public web stream, you may even want to disable the comment or the chat feature of something like YouTube. KDE, for board meetings of the state, the Kentucky Board of Education, they do that. The live stream of the KDE meetings is using YouTube. When you log on and watch that, the chat or the comment feature is disabled. That may be something that you also want to do locally, because let's say in a traditional meeting in person, if someone were to get up under your local policy and make a comment, maybe for up to 3 minutes, might be what's written in your policy, you would still have the ability, if they were to discuss something inappropriate or do something inappropriate or disruptive, you would have an ability to sort of address that and handle that in person. Whereas if it's just comments on a YouTube video, you wouldn't want your official meeting and your official school district YouTube sort of channel to really be used for someone to go on and say or put something that perhaps might be inappropriate on there for other people to see. So that might be another good reason that it's so impractical and difficult to allow for this, that you may be better off waiving the public comment now and even disabling any sort of public internet comments or chat features, depending on whatever format you use to live stream your meetings. That has come up. And I think the last comment on this issue as well, within the last couple of days, Katrina and her staff and others at the office had some questions come in about, does a school board have to record board meetings that are held via video teleconference and live stream? In other words, if you were to, let's say Facebook Live, if you were having your board meeting by video conference and the public was able to watch it just because you put it on Facebook Live, do you have to record that meeting also and then store it and allow anyone to come on and rewatch it at any time they want to from the general public? All of those rules are really housed in the state records retention schedule for public school districts. That is created by a state agency, the Department for Libraries and Archives. They create this record retention schedule for every type of record you can imagine that you might have in a school district. There are different provisions for how long you have to keep it, how you have to keep it, and so forth that govern what you do there. And just this week, Katrina and her staff published the Policy Connection and put some guidance and I think a link to that records retention schedule in that, which was shared with board members and the policy contact at each district. We encourage you to carefully review that policy as well. And Katrina, correct me if I'm wrong, it's been a couple of days since then. I believe that it boils down to there is no requirement that you record a video, the video stream of a meeting. However, if any district employee at the direction of the district does record it, whatever you use might record it automatically, depending on the technology that you're using. So if it's recorded automatically, if you choose to record it to help you draft the minutes of that meeting, Then if it is recorded by the district, you do have to keep that recording in the records of the district for at least 30 days after those minutes are officially adopted. And so I believe it says you don't just have to keep a district recording of it until the minutes are adopted at the next meeting. It's until 30 days after the minutes are adopted at the next meeting. That doesn't mean you have to keep it publicly available and on the website for anyone to watch on demand, but you do have to keep that recording in the records at central office. And it is, if it's created by the district, it is a public record subject to the Open Records Act. Someone could come and ask you to see that video recording, and it would be available for inspection like anything else. But we do want you to pay careful attention to how long you have to keep records such as that. Of course, if you wanted to have an online archive of all of the videos of your meetings, some districts have chosen to do that. Some school boards video all of their meetings publicly and keep all of them for years at a time available for the public to see. If you chose to do that, that would be a local decision. But we wanted you to really pay attention to that records retention schedule that was sent out through the policy connection from KSBA. And another part of that also says, at the 30-day mark, at 30 days after the minutes for that meeting have been approved officially at the next meeting, at that moment, if for any reason that video recording is under a request from someone under the Open Meetings or Open Records Act, if it is subject to possible litigation, if an attorney for any reason is asked for that, if for any reason that is sort of being challenged, you cannot destroy it at that point. Obviously, you have to retain it until whatever the given circumstance is resolved. And all of that is reflected in the guidance that we sent out and linked to. So thank you to Katrina and her staff for putting together that policy connection. Please always look for that in your email. If you did not receive an email for this issue within the last several days of the KSBA policy connection, check your junk folder, check any sort of email junk folder that it may have gone to. And if you did not receive it, please reach out to your policy consultant.
Yeah, that would have come from my email address. So it would have been Kinman at KSBA that it came from. So be sure and check in those spam folders.
And I think moving forward, that is the end of this presentation of the top 5 COVID-19 related issues specifically relating to and impacting things a school board needs to possibly take action on. For more information, please, as we said, contact first your superintendent and your board attorney. And then for more information from us, please contact your board's KSBA policy consultant or any KSBA staff, Katrina or myself or any of us, by reaching out to that 1-800 number there you see on your screen. Or also, please go to our website. We have a special part of our website that has been created where all of the guidance that KSBA has created and provided about the COVID-19 pandemic and links to all of the official government agencies that are putting out, in some cases, binding legal guidance on new laws that have passed and other issues, whether it's the State Department of Ed, Governor Andy Beshear's office, the CDC, or the U.S. Department of Labor about the federal sick leave and emergency leave acts that have passed. Links to all of that is available at ksba.org/coronavirus. So please check that out. Follow us on social media for timely updates of really pressing information that is coming out. And be sure at the link provided here with this video, for any board member that has watched this entire presentation and you want to seek self-study credit for your annual training requirements, the form to request that credit is provided at the link with this video. And if you can't find it, reach out to our staff about that as well. So with that, thank you so much for watching. And on behalf of Katrina and myself and everyone at KSBA, thank you for your local board service to the students of your community.